All right, David, do you want to introduce us to this case? It's an Establishment Clause case. It's a lemon case.
Yes.
It's all the things, and it was denied cert.
Yes. So this case is interesting for a reason I'll describe in mere seconds. It's called City of Ocala, Florida versus Rojas. And essentially what this is about is a prayer vigil. It's about a prayer vigil that was hosted in part by a city, by a police department that included chaplains from the police department. And essentially the question is, the underlying question of the case is, did this prayer vigil violate the Establishment Clause? But that's not what we're going to talk about. But I'll just read from the beginning a bit to give you some of the factual background, and then we'll talk about what is interesting about this. So this is from Justice Gorsuch, a statement respecting the denial of certiorari. It says, faced with tragedy, the city of Ocala, Florida, searched for ways to bring the community together. After a shooting spree left several children injured, police appealed to community leaders for help. A local NAACP official suggested to the chief of police that he contact religious leaders to facilitate conversations between residents and law enforcement. A local minister, in turn, proposed holding a prayer vigil for the victims. The chief agreed to organize the event, and police chaplains participated in it. I like this next sentence, Sarah. But instead of unity, litigation followed.
It was always thus.
Well, that could be like that could be a one sentence description of much of our political environment for the last 20 years. Instead of unity, litigation followed. Several atheists who chose to attend the event sued the city, alleging that the event's religious themes violated the First Amendment's Establishment Clause. So first, the district court granted summary judgment in their favor that it did violate the Establishment Clause. It says the court reasoned that individuals enjoy Article III standing to contest religious speech they find offensive, and that the vigil violated the Establishment Clause under the terms of a case called Lemon v. Kurtzman we've talked about. On appeal, the 11th Circuit agreed that at least one of the plaintiffs had standing to sue, noting that she had direct contact with prayer she found offensive. It didn't matter that the plaintiff went to the vigil knowing that she would be offended. What mattered was that the prayers reached her ears. Still, the 11th Circuit vacated the district court's decision on the merits, remanding the case for reconsideration in light of this court's intervening decision in Kennedy v. Bremerton School District. That's a case we talked a lot about involving the praying coach. This was the case that articulated quite clearly that the Lemon test, Lemon v. Kurtzman, was no longer good law. Now, what's interesting about this dissent from denial of cert?
Statement from denial of
cert. Statement regarding denial of cert.
As in,
yes.
Gorsuch agrees that they should have denied cert. Thomas is the one who's going to say, no, we should have taken cert.
Should have taken it. Yes, exactly. So the question here involves something called offended observer standing. Okay, so we've had a lot of conversations about standing. What is offended observer standing? And offended observer standing is a doctrine that has allowed, in the lower courts at least, individuals who are offended by a public display of religion. And when I say public display of religion, I don't mean a private individual publicly displaying their religion. I mean a public entity displaying, say, for example, a religious symbol, or a public entity permitting or participating in a prayer service, such as here, that for many years, if you were a plaintiff, you could actually go into court and claim and have an your Establishment Clause claim heard on the basis that you were offended by the display of religion without showing any other underlying harm. Just seeing the cross or hearing the prayer was offensive to you, and that granted you standing. And this has, Sarah, long been an outlier in standing law, because as a general matter, the fact that I'm offended without any other evidence of harm doesn't give me the ability to get in court. So if you're a public official, for example, and you're a Republican and I'm a Democrat, and you say those Democrats are demonic instruments. No, let's not use demonic because that has religious connotations. Let's say those Democrats are, or those Republicans are evil or whatever. Even if I'm on the opposite side of you and I'm really offended by your insult, the mere fact that I'm offended doesn't give me the ability to get into court to challenge your statements. But in the Establishment Clause context, the fact that I might see a cross or a nativity scene or hear a prayer has been enough to get you into court. And so this is what was initially before the court, was this very notion of offended observer standing. And the court said, nope, not going to hear it right now. The lower courts are going to reevaluate this entire case under Kennedy v. Bremerton. So we don't have to deal with that right now. And Gorsuch was saying, at some point, we're going to have to deal with it. And Thomas was saying, we should have dealt with it now when it comes to offended observer standing.
So here's my question. And I agree with you. And we've talked about this. Standing is a mess at the Supreme Court right now.
It's a mess.
It depends on which, what merits doctrine you're actually challenging in terms of then what the standing is, which is backward, right? Standing is how you have to get into court in the first place. It shouldn't be particularly relevant in that sense, whether it's an Establishment Clause case or a Spending Clause case. You should either, have this particularized harm or not. And in that sense, the offended observer standing has always seemed strange because it seems like a lower bar than, for instance, taxpayer standing. At least taxpayers can point to something, albeit very, very small, that yes, your money was spent on something that you think violates the law. Therefore, you have an injury and you can go to court. No, we all know that taxpayers don't have generalized taxpayer standing, regardless of the fact that you can point to 1 penny of your money went to something. And therefore, you get into court to be able to challenge why it might be unlawful. This is the whole student loan case problem. And so in that sense, offended observer status seems like an even lower bar. However, David, how is one supposed to challenge Establishment Clause stuff if being a person who observes the government establishing a religion, let's make it more egregious. This obviously is not a particularly egregious case. I'm not offended by it. And so in that sense, the sort of eggshell plaintiff side of this is a bit of a hot mess. But let's take one where, let's take the 10 Commandments case. Part of the reason that was upheld.
The 10 Amendments would be the Bill of Rights.
Whatever. Also an establishment of something. All right. The 10 Commandments case. This is, back, God, it's now been 20 years or whatever it's been, outside of the Austin, Texas state legislature, there's the 10 Commandments monument, but there's also a zillion other monuments and a flamingo. And, basically it was if there's a menagerie, that's kind of fine. David, let's assume that we change the facts of that and Texas removes everything else and now replaces it with a giant 30-foot Jesus is King 10 Commandments monument that you have to walk by in order to get into the doors of the Texas state legislature. Who has standing to sue other than someone who observes that and is offended by it?
Yeah, that's a really good question. And it really it raises this issue that, okay, there are some violations of the Constitution for which there is no judicial remedy.
Nobody's going to like that answer.
No, lots of people are not going to like that answer. And one of the key areas where that is most true is one of the areas that is most consequential to all of our lives. And that is war and peace. So, for example, the Constitution states that it's Congress that shall declare war and presidents are commanders in chief. And so in theory, there is a way in which those two political that the president could violate the Constitution by initiating military action. Something that's incredibly consequential that can cost people their lives. And yet the court has generally held that to be not justiciable. That is a conflict left to the political branches of government. The court isn't going to enjoin a war, in other words.
But I see such a huge difference between that and an individual right.
Right. Well, and I think the question, one of the questions that you would have is
because, and let me tell you why,
if
by
you're
the way, just for listeners.
okay, go ahead.
Because what you're talking about is a structural delineation in the
Hmm.
Constitution. And so the institution that is being offended in that sense, Congress, has other tools at its disposal. It can impeach the president, it can withhold appropriations. I'm not saying those things are likely, but that's sort of some of the built-in structural parts of the Constitution as well, which could protect those institutional rights. But when we're talking about an individual right against, as it started, state governments, sorry, Adam, fix that. But we're talking about an individual right, which initially, of course, was to prevent the federal government from establishing a religion. I guess I feel less comforted by that explanation that it may just not be justiciable. Then why have the Bill of Rights at all?
Well, I think that some of the difference is, so for example, if I have a free exercise right, which is unquestionably an individual right, which is I have the ability to exercise my faith, and the government steps in and says, you cannot have your Bible study. You are stopping me from exercising an individual right, in the same way that if you say you're going to be expelled from school for saying these words that the government doesn't like, then I have a concrete harm and a violation of my individual right. Now, the Establishment Clause in some ways isn't so much talking about an individual right, in the sense that if what I'm looking at is a 10 Commandments, it's not that I have an individual right not to look at the 10 Commandments. The question is, in what way does how would an Establishment Clause violation violate my individual rights, is less clean than saying, how could a prohibition against me exercising my faith violate my individual rights, or how could shutting down my newspaper violate my individual rights. There are Establishment Clause violations that absolutely do implicate your individual rights. The question is, when it comes to something along the lines of, I'm required to see a 10 Commandments display, or I hear a prayer that I don't like, is that really a violation of your individual rights? It can be unconstitutional, but is it a violation of your rights, Sarah? That's the question that I think is interesting about some of these Establishment Clause cases, because I can see any number of circumstances where I could say the government has violated the Establishment Clause, but I cannot trace and I cannot establish an individual particularized harm that I have suffered as a result of that violation of the Constitution. And I think that's where people really wrestle with this.
All right. I hear you through that, and I'm somewhat persuaded. And then it gets back to what I was dissatisfied with, I think, in the Kennedy opinion, which is that in the school context, there needs to be a more clear coercion test. Because if we get rid of offended observer and we sort of have beefed up free exercise, we're back to and worsened by the problem that I've described when we talked about the Kennedy decision and argument, and I've beaten this horse, so I won't go into it too much. But this idea that me, a high school student in orchestra, had to sit through a Christian prayer before orchestra concerts. If we just say, like, well, it doesn't matter that you sat there and were offended by it, I think it has to be different in a school context where the student either has to be at the school because it's during school hours, or it's an extracurricular activity that the student is doing. It is an official school function. To say that I don't have to be in orchestra would seem to miss the point, just because it was an after-hours concert. I do see a distinction between that and a government organized and participated in vigil that this person voluntarily went to so that they could then sue about it. One of those is just more sympathetic than the other. And so I would hate to make the law based on what I see as frivolous litigation on offended observer status versus high school, junior high, elementary school students who are actually having what I would consider far closer call establishment cases in their schools.
Yeah, it's a really, so I've actually filed an establishment clause case in my career and won it. And so the facts here, let me tell you the facts of the case that I filed and won. And it was against Georgia Tech, Georgia Institute of Technology. And they had a safe space training program. This is going back to the early 2000s. So if anyone thinks that like safe spaces are this brand new thing, I got news for you. It's amazing how many people think that nothing bad happened before Twitter, but the safe space training program had a curriculum on religion and different religious organizations, and the training materials very clearly, and these were training materials that were aimed at students, for example, strongly preferred religious traditions that were more affirming of LGBT sexuality than those that were not. And so the shorthand of this would be Georgia Tech's official position that it was teaching students was it's better to be Buddhist than Baptist, right? So you had actual instruction from the state preferring one denomination over another, that this is what the state was actually teaching students. And in that case, there wasn't offended observer standing. The problem wasn't, well, I'm offended by this teaching. The issue was much more closely related to the coercion test that you're talking about. And I think that's you're hitting on something really important. What is the distinction between I just don't like what I see versus this is what the state is actually telling me is true to the exclusion of other traditions, and I'm a captive audience. And so that's where I see the individual right aspect of it coming in more clearly to view.